Question 13. Under tort law, a loss may be held to be too remote if answer. A loss may be too remote if it was not reasonably foreseeable that the action could cause the loss, or if it does not pass the but-for causality test. But for the act, a loss would not have arisen. As well, too much time between the action and the injury might lead to a finding that the loss was too remote from the tortious act. Question 14. Under the thin skull theory, plaintiffs who are unusually vulnerable due to physical or psychological infirmities would answer. Under the thin skull theory, plaintiffs who are unusually vulnerable are still entitled to damages for all their losses. However, if a normal person would not have suffered any damages, the plaintiff would not be entitled to damages. Question 15. In terms of product liability, there is a duty of care on a Canadian manufacturer to give consumers warning. Answer. Under Canadian product liability law, there is a duty of care to give consumers warning when, even though a product is not defective, dangers may arise when it is used. The duty to give proper warning is a continuing one, so that notice is required whenever a company becomes aware of potential dangers in a product's use. Question 16. Professionals are liable for negligent misrepresentation when they make an incorrect statement. Answer. Negligent misrepresentation is the making of an incorrect statement made without due care for its accuracy. Plaintiff must prove he or she relied on the statement. However, the professional's duty of care has been limited by case law to a class of persons with whom the professional has a special relationship, i.e., who use the information as part of a contemplated transaction. Question 17. What are dividends? Answer. Dividends are declared by directors at their discretion. They are not owed, and shareholders may have no remedy if they are not made. They are repayments of capital, not interest. They are made out of after-tax profits and thus are not tax-deductible. Question 18. Corporation A was issued a loan by Bank B. Corporation A is now claiming that its chief financial officer did not have the authority to obtain the loan and therefore is refusing to honor the terms of this bank loan based on the indoor management rule. Answer. In the absence of notice of irregularity or suspicious circumstances, everything in the operation of a corporation that appears to be properly done, such as a CFO borrowing money, may be relied on by an outsider and will bind the company unless a contracting third party knows about a particular restriction, in which case such restriction would be binding. Question 19. This complete defense to a tort action asserts that the plaintiff freely agreed to accept the risk of injury or loss. Answer. Voluntary assumption of risk. When the plaintiff freely agrees to assume the risk of injury or loss is a complete defense that would lead to the defendant not being held liable. Question 20. You insist that a supplier send a rush shipment of part, thereby leaving the supplier out of stock and unable to send parts to the plaintiff with whom it had a prior agreement of sale. You are. Answer. The behavior constitutes interference with contractual relations since you persuaded a third party, the supplier, to break its contract with the plaintiff. Intimidation involves threat to commit an unlawful act. Question 21. What is the remedy in civil litigation is designed to make the guilty party fulfill his or her obligation or promise to the injured party? Answer. Specific performance would require the defendant to fulfill his or her obligation. Compensatory damages may commence to the victim for the loss suffered. Question 22. What is requirement for a class action suit refers to one or a few people having a workable plan for pleading the case on behalf of a whole class of people. Answer. The representative plaintiff is the person or persons who are judged to have a workable plan for pleading the case on behalf of a whole class of people.